Welcome to the Real Estate Power Play Podcast, your launch pad for skyrocketing success in real estate investing. I'm your host, Gabe Rodarte, alongside Mark Monroe. We're ready to bring you transformative stories, groundbreaking strategies, and the insider secrets of real estate giants. Get ready to accelerate your investment journey and become a true power player in the world of real estate.
So my family has relocated. It just kind of evolved. It was never intentional, but we've actually relocated for at least the next 4 years to Wisconsin. So we're
Very
not
cool.
living in Arizona. We still have a house there that we're actually going to end up renting just because we're not going to be there full time anymore. So so a little bit of a
That's
change
awesome.
there. So
Where
yeah,
where in Wisconsin?
Sheboygan.
I don't know it.
So it's an hour north of Milwaukee. It's right on Lake Michigan. In fact, they call it the Malibu of the Midwest because you can actually surf on Lake Michigan generally a couple days a week. It's relying upon the wind, but they'll be out there. And I did it a few years back when we were just vacationing up here, and then we haven't been here that long. But this summer I plan to pick up a board and wetsuit and give it a go. I grew up in Southern California, so
Nice. Whereabouts?
In Southern California.
Yeah, whereabouts?
Downey. It's a suburb of LA.
Okay. Very nice.
Are you familiar with
a little bit? Yeah, my other half, she grew up in LA in the Valley, but her other sister Liz. So when we're standing at Manhattan Beach and we look up to the left, what's that area called? Palos Verdes or Palos something?
Yes, Palos Verdes.
Yeah, so she lives up there.
Okay.
So we spent some time from there, and then her rest of her family kind of moved out to Palm Springs area.
Okay. Yeah. So we're southeast of LA. Downey is. It's about 25 minutes without traffic, and we're about 20 minutes from Long Beach, kind of in that area, if you're familiar.
Yeah, her daughter was out there. So anyways, I hit the record, so we're talking away, and we'll just let the people take it from there. So just want to let you know we are recording. So we're not going to go live. We're just going to record everything and just talk about it, and then it'll come out probably this week or next week in the podcast. So anyways, I'm just going to go, and we'll start, and he can move this around. But thank you guys for joining us on another episode of Real Estate Power Play. And I have the honor to have Sean St. Clair, a real estate attorney, and he really specializes in helping a lot of us seller financing and creative investment investors out there. So Sean, thanks very much for coming on. And, I've been on your podcast as well. Thank you for having us on your podcast. So why don't you kind of introduce yourself to everybody?
Thank you, Mark. I appreciate you having me on today. So as Mark said, I'm an attorney. I'm licensed in Arizona and Wisconsin, and my practice really focuses on representing real estate investors in their real estate transactions and business ventures. So, in the real estate transaction arena, it's anywhere from creative financing to wholesaling, the novations to just general purchase and sell agreements, due diligence on commercial real estate, title review, title clearing, dealing with title issues, getting those cleared. And then on the business structuring or planning, that's, setting up entities, putting together operating agreements, joint venture agreements, and then, which I believe should be complementary to that, is estate planning. So I will do estate planning because, frankly, if you set up a business and a structure, the top of that should be some estate planning mechanism like a trust, so that if something happens to you as the owner, somebody can step in right away without going through probate and operate your organization. And so if you're not doing that, you're kind of, in my view, missing a step. So that's kind of my practice. It kind of runs that gamut of, working with investors in the transactional areas of their practice and businesses.
That's awesome. Well, that's great. I'm going to throw a bunch of questions at you since you're on and have the opportunity here. So, well, thank you so much, Sean, for reaching out. Anyway, Sean, again, thanks for coming on. I appreciate it.
Absolutely.
I have a couple questions. Let's talk a little bit, especially in the subject to, because you know subject to very well, and I want to talk a
Mhm.
little bit about the title insurance. And this actually just happened to me just recently on a deal. I closed on a subject to deal about 5 years ago. And the scenario on this particular one, it was I thought it was a husband and wife. I don't recall. He passed away. And so she had, from what I understand, she had the right to sell it. So she provided the deficit to the title company. The title company closed on it. I purchased it subject to, fixed it up, and then I flipped it and I sold it to my end buyer. So we get a notice um, just recently that there's some heirs that were entitled because he passed away, and now they're looking for like $9,000. I had title insurance on it at least, so I just turned that over to my attorney here in Florida that handles that, and then I know my end buyer got title insurance. So tell us a little bit about something like that, and then also what happens if you purchase a property. And I've done this before where you don't get title insurance because the closing agent didn't offer it. And then you hear stories like, oh, the seller had title insurance before, but what happens in something like this? I'll let you dive into it.
Yeah. So the way title insurance works on subject to transactions is you do receive title insurance basically as though you were purchasing it traditionally, with one exception. And the exception is that the existing mortgage loan that you're taking it subject to is going to be listed as an exception to coverage under the policy. So if that lender comes out of the woodwork and calls the due on sell, if they start other foreclosure proceedings, claim there's some breach of the loan documents, and you go to the title company and say, hey, I thought this was all taken care of, now they're claiming that they can foreclose on me, the title company is going to say, well, we put that as an exception, we're not covering that. But they are covering other things like your scenario, which is, hey, all of a sudden these heirs are coming out of the woodwork, they want money. Well, in that scenario, even though it was a subject to transaction, as with any real estate transaction where you have a seller or an estate that is selling the property, the title company's job is to make sure that all the ducks are in order, that the right person is signing the paperwork, that they have the proper authority, that there's no additional court approvals. That's what the title company's job is to make sure that everything's in order so that no heirs can come out of the woodwork and say, hey, look, I own this property. So it is wise, even though you're taking it subject to. I have clients who are like, oh, I'll just self-perform. It's like, why are you going to do that? It's title insurance, not that expensive. And then when you have a situation like what you're dealing with, Mark, it's like, oh, I wish I would have paid that. Versus, I'm guessing in your case, the title company is going to pick it up. They're going to negotiate with the heirs. They're going to defend you, and they will resolve it. It's a little bit of a heartache when you first get that letter, but at the end of the day, that's why you have title insurance. You tender it to them, and they handle it. And it doesn't matter whether it's a subject to, because you can get title insurance for subject to transactions. Now, there are certain transactions that you can actually get title insurance after the closing, but you cannot close through a title company. And those are FHA transactions, subject to transactions. And so title companies will not, or escrow companies will not touch them for the purposes of performing the escrow. But if you self-perform, if you close without title insurance, then you can go and actually go to a title insurance company and say, okay, I bought this house, we closed 2 days ago, and I need to insure it. And in fact, the title companies will even issue commitments, so everything's in place. You know what needs to be done for the insurance policy to be issued. You know how much it's going to cost. You go, you deliver the recorded deed, because that's what they're doing, is they're insuring a recorded deed at that point. So they're not insuring a closing. Closing's already done. They're ensuring that that deed basically gives you title to that property subject to the existing loans. So you go and you deliver that to the title company with your premium, and then they issue a title insurance policy on it. But you do have to self-perform. You do have to close that outside of escrow, and then you go and work with the title company to get the post-closing insurance. And then I think you also asked, well, what if somebody just says, I don't need title insurance? What does that look like? Well, that looks like basically you're going to go and once again, self-perform the transaction. And so the way that would look is you put a purchase contract together, you do all of the required, addendums and all that good stuff. And then from there, you will be responsible, you and the seller, for that matter, are responsible for putting together the warranty deed, the promissory note, the deed of trust, or the mortgage, if you're going to wrap it. You put all that together. I highly recommend, even if it's outside of a title company, doing a settlement statement or a closing statement that everyone signs. So everyone, the seller can't come back later and say, oh, I thought I was getting, 50 grand from this. And it's like, no, here's the settlement statement or a closing statement you signed that said you're getting X amount of dollars, and here's my check. I paid you X amount of dollars. And then basically you deliver the money and the promissory note or mortgage or deed of trust, if you do a wrap, which I highly recommend, and you deliver that to the seller in exchange for the warranty deed. And then you take the warranty deed and the deed of trust and you record them, or the mortgage, if you're in a mortgage state, and you record them and you're done. That's the transaction. So, and you don't have title insurance. So if you have, if you're dealing with an estate, or like you said, a married couple, and maybe you should have gotten the spouse's signature, like in Arizona, just because one spouse is on title and you look at it and think, oh, great, I just need one spouse's signature. Well, it doesn't work that way. Community property means that even if a spouse isn't on title, they very well could have a community property interest. And to me, that's why title insurance is so important, because the title companies will identify that, because they don't want an issue and say, oh, no, we either need to get a disclaimer deed from a spouse, or we need to have them sign and approve this transaction, so that you don't have those issues come up later on that you just didn't know they would even be issues.
Interesting. But what's weird is when the letter came from, it came from the title company, like the title insurance company or something like that. I've never seen that before.
Interesting.
Yeah. Anyways,
Yeah.
I'll let the attorney, but I'm sure. But that's great info. So now, what would happen? Like, let's say, for example, I do have title insurance on this, and what would happen? Like and I sold it to the buyer, and they didn't pick up on it either, and they got title insurance. So it really went down the chain a little bit already. How does that work?
Mm-hmm. So normally, once you convey the property, your title insurance lapses and the buyer's title insurance policy then takes over. And that's generally the policy that will pay out. So in your scenario, since you did do a disposition already, it's probably good to, and your attorney, I'm sure, will take care of it, but, to basically place it under the buyer's policy. If your carrier, which they very well they may come back and say, well, you don't own the property anymore, Mark, so we're not going to cover it. And then it reverts to the buyer, and then it becomes the buyer's issue to deal with from a title policy.
Got it. Okay. So a lot of good information there. Now, what would have happened in a scenario if I didn't have title insurance? Was in this case, it'd still go to the buyer. They'll probably still go down to the buyer's policy. But in that type of case, or like say if I'm still holding it and I'm renting it out and I didn't buy title insurance, then what would happen?
So
Whoops.
then,
Sorry.
yeah, oh, no problem. So then what would happen is, if you didn't have title insurance, you still own the property, and you get a demand from the heirs. Well, you don't have an insurance company that's going to cover you. However, personal representative of the estate, or whoever took responsibility for conveying title to the property, they signed a warranty deed. And a warranty deed is just that. It warrants good title to the property. So it's a representation and warranty that they are conveying good title of the property to you. Because otherwise you don't do a warranty deed. You do a quitclaim deed or some other bargain and sale deed, or whatever other deeds out there where you're just conveying whatever interest you may have. A warranty deed is actually a warranty of title. And so when you execute a warranty deed, you're saying, hey, I'm Mark, I'm conveying good title to you. So you may have to resolve it, but you would then have a claim against whoever signed that warranty deed for a breach of the warranty of title, and you could actually sue them and try to recover whatever damages this has caused you, because clearly they didn't give you good title even though they warranted it.
Okay. Good stuff. Really good stuff. So, is there anything that I didn't ask regarding title insurance that I should have asked that would be good information for the listeners?
One of the things that I think a lot of times is overlooked with, especially on residential real estate, is going through that title policy and making sure that there's things in there that aren't going to come back to bite you, especially in the exceptions. So, when I do commercial work and commercial due diligence, I mean, I look over that title commitment with a fine tooth comb. And we go and we always object to certain exceptions and things. If the title commitment references CC&Rs, for example, and I know what my client intends to use the property for, I sit there and basically review the CC&Rs almost word for word to say, is there anything in here that's going to affect my client's ability to use this property? And so there's CC&Rs, especially in Arizona, and I'm guessing down in Florida as well, that try to restrict things like rentals, especially shorter term rentals, leases for less than a year, those types of things. And so it's very important for you to identify, how am I going to use this property? And is there anything in here in this title commitment, in the exceptions, such as CC&Rs, that is going to impact or affect my ability to use the property for its intended purpose? And unfortunately, people close and then they find out that the CC&Rs prohibit them, or there's some, plat that was recorded that has restrictions or other deed restrictions, and they realize, oh shoot, I have a real mess on my hands because now I can't use the property the way I wanted. So be very diligent when reviewing that, and don't let it just be some document that goes into your inbox and you don't even look at, which I think is what happens a lot of times, honestly.
Yeah, I agree with you on that. I just kind of glance at it, and I think that I just think the title company knows what they're doing and protecting me. That's kind of the
Right.
thought process. But you're right. I know my background is real estate banking, and I know my underwriters always used to look at it, and but you're right. As an investor, we don't really look at it, and we should. So that's some great advice. Thanks so much. So I want to go on to something else. I was talking to one of my members in my program, and he has a property. He was trying to sell his own property subject to it's his own personal residence, and he had
Mm-hmm.
somebody else open to it, and he didn't explain it correctly how the wrap works. And the guy's like, and they just had in the mindset deed of trust. Oh, I'm going to get the deed of trust, and so it sounds like there's a miscommunication breakdown there. Why don't you kind of really explain really what a deed of trust is? Because a lot of people get confused. They thought it was like a trust, like a land trust. That's kind of what they're
Right.
thinking.
Yeah.
So there's a difference there. So you want to kind of
Yeah.
explain that a little bit?
Yeah. So a deed of trust is used a lot of times synonymous with the term mortgage. And it is very similar to a mortgage, which is basically a lien against real estate, which secures the repayment of a debt. And so there are some states that use mortgages, and then there's some states that use deeds of trust. And they're very similar instruments, with one very important exception, which is a deed of trust allows a lender. So the deed of trust is for the lender's benefit. It's basically the lender's lien against property. The deed of trust allows the lender to foreclose on the property without filing a lawsuit, versus a mortgage requires the filing of a foreclosure lawsuit with the court. And that's the big difference. That's why, we like to use deed of trust states if we can, and use deeds of trust when we can, because mortgages, it's more costly and more time consuming to foreclose. But a deed of trust basically is pretty much the same as a mortgage, with one major difference, which is how you foreclose.
Got it. So let's talk a little bit about that. Like, is it different court systems that you go through the process, and what's the time difference between the two?
So the deed of trust can, and I don't know the time periods in every state, but I do know, for example, the shortest state I've ever heard of is Texas, which is 21 days from the date that there's a default that would allow for a foreclosure. You can record the notice of trustee sale and foreclose on the 21st day, which is huge. I mean, that's quick for a lender. Arizona, for example, is 90 days. So once there's a default that would allow for the starting of foreclosure, you record the notice of trustee sale, and then on the 91st day after that notice is recorded, you can foreclose. So, anywhere from 21 to 91 days is what I'm aware of as far as timeframes for trustee sales. I haven't heard of any states that are longer for that, but they may be out there. As far as a mortgage goes, though, generally speaking, there you have a 6-month redemption period for judicial foreclosures normally. Roughly, that's kind of, it could vary by state. So some states might be less, some states might be more, but normally it's going to be in a 6-month period for redemption. And what that means is you file the lawsuit, you serve the lawsuit, you get a judgment, the sheriff holds a sale, the sale is completed, and now 6 months after the sale, the borrower or the borrower's successor can come forward and pay all of the basically back amounts. They can pay the judgment amount, they can pay the loan amount, as well as the sheriff's fees, the attorney's fees. They can pay everything that's owed on the loan, and then they can redeem the property, and it's like it never occurred, and the lender gets paid in full. But you still have that 6-month redemption period where basically you can't do anything with the property. It's just there waiting to see if this borrower is going to redeem. So with all that told, in a mortgage state, it's going to be roughly 8 months to a year before you can actually complete a foreclosure of the property.
Got it. So you're saying in the state they foreclose on it like a lender, and they have to sit on it for 6 months? Is that what they do?
Yeah, that's correct. So in Arizona, we have the ability to do mortgages, even though nobody does them. And if you do a mortgage, then you have to judicially foreclose, and that's exactly how it would play out. Wisconsin's similar. I think the redemption might be a little bit less now, but at one point it was 6 months, and it may be less depending on whether or not you're seeking what's called a deficiency judgment or not, which is, hey, if the loan is 500,000 and the property is only worth 300,000, who gets that $200,000 difference? And if the lender is claiming that, then the redemption is going to be longer. If the lender is not claiming that, then it could be as short as 90 days. But normally you're right in that 6-month range throughout, for a lot of states as far as the redemption time periods.
Got it. Okay. That was really informative. Good stuff. Is there anything that I didn't ask that I should have asked on regarding deed of trust and mortgages? I think you covered most of it.
Yeah, I think I covered most of it. Yeah, that's the main difference is how you foreclose, really.
Okay. Let's jump over because I know you specialize also in novations. Let's jump into that subject for a brief time.
Okay.
And then after that, then I want to ask you a little bit about, setting a business and asset protection and the trust. So,
Mhm.
so anyways, on a novation agreement, you want to kind of explain to everybody what a novation agreement is and the pros and cons about it?
Yeah, so basically what a novation is, it's a replacement contract. So it's where one contract replaces another contract. So it's replacing one obligation with another. So in the situation of real estate, for example, the way it operates, and this is the legal definition, it operates maybe a little different than this in practice, and we'll talk about that. But in the legal scenario, I enter into a contract with you, Mark, to buy your property. then another buyer comes along and says, hey, Mark, I want to buy your property. And you're like, well, I have it under contract with Sean, but let's see if Sean will allow for a novation, which is whether or not I can sell it to you, third party buyer, and basically replace Sean's contract. And generally in that scenario, there's some level of compensation that would then be paid to me to convince me to novate, to cancel my contract and replace it with this other contract or obligation. That's essentially what a novation is taking this other contract out here and putting it on top of the other one and replacing the prior existing contract. And so there's clauses you can put in. So like you and I could have a clause in my agreement that says, yeah, Sean, you will novate, but to do so, I will pay you X amount of dollars to cancel your contract, if that makes sense. So you can put a novation clause in at the beginning that requires me to allow the novation, but generally I'm going to negotiate some level of compensation to me for that. So that's legally what a novation is, as basic level.
Got it.
Now,
go ahead.
Now the way it works in the real estate realm is basically it's not so much, it is a negotiated term between the seller and the original buyer, but it's really the original buyer that's kind of facilitating the negotiation, as opposed to in the hypothetical I was giving with you, where you're kind of facilitating as the seller. The buyer facilitates it. And the reason why novation tends to work in certain scenarios better than assignments is a novation puts the end buyer in direct contractual privity, which is a legal term of art, but basically the end buyer has a contract directly with the seller, and there's no assignment in that chain. It's simply end buyer and seller, and that allows an end buyer to actually obtain traditional financing. And then the original buyer is compensated through like a cancellation fee, or if they've recorded a memorandum, a release fee for their memorandum. And that is how they are then compensated is, hey, yeah, you have a valid existing contract, so we need to cancel that. We need to release that memorandum. And so their compensation is based upon them basically agreeing to remove their contract from the transaction. And that compensation can be paid at closing, and it is in practice paid at closing. And the novation isn't effective if it's structured right and stated right. The novation isn't effective until that transaction between the seller and the end buyer actually closes. Otherwise, if that falls out, then the contractual rights revert back to the original buyer. Normally.
Interesting. Yep, very nice. So I have a couple questions here within that. So you need a really good closing agent or title company that understands these type of transactions, correct? So then you would give them both contracts. Is that the typical case what they do?
No, you would not give them both contracts. So what you would do is you would give them the original, not the original, the final contract. So they would get the final contract, and then you would give them your novation agreement or novation addendum, which basically explains how you're compensated for canceling the original contract. But they don't need the original contract because that's not part of the escrow anymore. It's going to be no more. It's being replaced.
So typically there'll be they have a contract with the seller, and then they would have a novation agreement in place as well. And then I've also heard that sometimes they will do what's called not a power of attorney, an attorney in fact. So what's the difference between a limited power of attorney or attorney in fact?
So a power of attorney is a legal document that's created by statute within every state, which is notarized, witness if witnesses are required, but it basically complies with all the statutory requirements. An attorney in fact is an informal agency appointment. So the law of agency provides that I could right now say, hey, Mark, you have my authority to enter into a purchase contract on my behalf. And me telling you that creates you as my agent. It's an express verbal agency where you could enter into a purchase contract. And if the seller saw our video today, they could say, oh yeah, Sean gave Mark the permission to enter into this contract. And so Mark has the authority to enter into this purchase contract on behalf of Sean. And that would be a binding purchase contract as to me and the seller, because I gave you express authority to do that. However, once you enter into that purchase contract, your agency is no more because of the fact that it was for a limited purpose here. And I didn't give you a power of a general or a limited power of attorney that allows you to continue to act as my agent. So what the attorney in fact is a written agency appointment that does not rise to the level of a full power of attorney recognized by statute, but it complies with the common law rules of agency that allows for the agent to do whatever's described in the attorney of fact and to do those on behalf of the principal. So in the novation setting, my preference is get the limit. Well, I have two preferences. So the first preference is have the seller execute everything. That would be my preference. So if you have that third party contract, my preference is you're communicating with that seller, the seller knows what's happening, and the seller signs that third party contract, and the seller signs all of the escrow documents, and it's a smooth transition. Everybody's on the same page, and it closes smoothly that way. And then you have less concern about upset sellers, upset buyers, the whole thing. The second preference is if you're not comfortable or you're not willing to do that, my second preference is to actually get the statutory power of attorney, limited power of attorney signed that gives you the authority to formally act on behalf of the seller. Then if you don't get that, you can do the attorney in fact, but that's kind of the lowest level, I think, and I'm not a big proponent of. I'm not a big fan of it. It can be done that way, don't get me wrong, but when you start talking about best practices and the things that are going to keep you out of hot water should a dispute arise, and you may be perfectly within your legal right, but this, Mark, nobody wants to pay an attorney to prove that they're within their legal right. And so the easiest way to do that is that level of prevention. And so, the attorney in fact is kind of that lowest level of authority. You can do it legally, you can do it, but title companies won't close on it, right? So if you use the attorney in fact, that allows you to enter into purchase contracts and addendums to get escrow open. But once escrow is open, then from there, the title company is going to want either a formal power of attorney or they're going to want the seller to show up and sign. My preference on those is still to have the seller show up and sign and close the transaction with their signature.
Yeah, and that's probably, I recommend that too. That's the easiest way. The other thing the attorney in fact does allows the buyer that did the novation to also to be able to market the property as well and put on work with the MLS and as that.
Yes.
Right. The other reason, and let me get your thoughts on this. I've heard a lot of people doing, and I've actually done this myself. I've done a novation agreement where a property needs work, and I agreed to the seller, this is how much money you're going to net, and we end up putting about $50,000 into the property for improvements. And then when we closed on it, then we got the difference on that. What are your thoughts on that?
It's risky. And the reason why it's risky is you could end up with title issues that you didn't contemplate, such as all of a sudden you realize, wait a minute, the person I've been working with is supposed to be the full owner because they were married to the deceased party, but all of a sudden now the deceased party has heirs, who now have to sign off, and the heirs aren't willing to sign off even though you put 50 grand into the property, right? Or there's other title issues up there. A judgment gets entered against the seller right before you go to close, and now you are having to deal with that. Or the seller, you get sideways with the seller and the seller refuses to close. And now not only are you out 50, but now you're paying attorneys for specific performance and those types of things. So it can be done. I think there's some things you want to do for protection purposes, such as, definitely make sure your purchase contract allows you to record a memorandum. It may not hurt as well to, put a promissory note and deed of trust in place, even if it's 0% interest and, um, doesn't really have a term of repayment other than upon the sale of the property. But at least you have something locked in against that property so that if you do get sideways with the seller or there's a title issue or something else, when the property does eventually sell, you can at least you have a lien there to get your money out of it. Obviously, before you do that, because there could be different regulations on that, depending on what state you're in. Consult with an attorney, have them draft up the forms, make sure there's proper disclosures, all of that. And even just the novation transaction in general, make sure you're doing all that. But if you're going to start putting money in and taking liens and notes and things like that, you better make sure that you're, perfectly in compliance with whatever state laws you're operating under. And you're not going to, violate any type of mortgage banking laws or violate any foreclosure reconveyance statutes or things like that. So you just have to be very careful when you're doing this, and to have every document that you need in place, have all the disclosures in place, and make sure that you can even do it legally under your state laws.
Got it. That makes sense. That's good. So that's probably the best. Or do you suggest another, like if there's a certain state where they can't do it, and do you have any other suggestions and a certain strategy how to do something like that? If, you where they have to put money into the property and they can sell it like 90 days to 6 months later, um, besides a novation, what about like a subject to or anything else, or any
Yeah.
other type of creative way that you have your thought process on that?
So one way that or one transaction structure that I've utilized, actually there's two transaction structures I've utilized, and they're executory contracts. So the first is where we've had title issues or pending divorces or probate issues, things like that. I've used land contracts or agreements for sale, contracts for deed. And those are just executory contracts where you can go in, basically take over the property. Title still remains in the name of the seller, but you have basically full authority to deal with that property. You can repair, maintain, improve, lease, pay expenses, hire contractors. You can basically do everything with the property as though it's yours, except title remains in the seller. So that's one way. The other way is to do a lease with an option to purchase. And so you basically lease the property, and within your lease, because normally tenants on residential property don't have this right, but if you build it into the lease, you would. In the lease, you would put that you have the right to repair, maintain, improve, construct, build, basically do what you want to do with that property, and build that into your lease. And then you have an option to purchase, and then come 6 months or 3 months or however long it takes, then you exercise that option. And frankly, you could even find that in buyer and then exercise the option as part of that same closing, and then the money just flows that way.
Interesting. I've done hundreds and hundreds of lease options on that stuff. I call it like sandwich or whatever you
Yeah.
want to call it. But whenever it comes time to put money into a property, I don't feel comfortable as the investor putting $50,000 into a property if I don't have control of the deed or control of it. That's my feel. So I prefer doing like the agreement for deed and have everything signed and sit in
Yeah.
escrow. That's kind of what I prefer.
Yeah, that's my preference, is to have like an agreement for sale or contract for deed with a pre-signed warranty deed that's being held by a neutral third party, whether that's a escrow agent, a loan servicer, an attorney who basically can deliver it when there's been performance under the contract.
Is there a timeline, like say for example, like you have the warranty deed, everything signed, and it sits in escrow 5, 10 years or anything like that, is there any time statute that it's never been recorded, but it's been
At
signed and
least in
notarized? I'm sorry.
Yeah, so agreements for sale have been are recorded documents. So you lock in your position on the property with a contract for deed or land installment contract agreement for sale. It's all the same document, just each state calls them different. But you lock in your position on the property, and that is a recorded document. So the answer is no. You can, I mean, those could be for 30 years, and the warranty deed can be held for that long, and it doesn't become stale because part of the statutory framework for these agreements provides that if if the parties agree, you can have the warranty deed held by a neutral third party. Now, what about a purchase contract where it's just a purchase contract? Can you have an extended escrow on those? And the answer is yes. At least in Arizona, there is no restriction whatsoever on the timeframes for an escrow. In fact, I had a transaction. It was on a commercial property, but it was in escrow for 4 years. COVID played a role in that, as well as certain entitlement issues and things like that. But originally we were going to close it in a couple of years, and then COVID hit, and we extended it for a couple of years. And it was in escrow, literally with an open escrow for 4 years, and we closed it. So it can happen. And I actually really like that strategy for dealing with subject twos where you're really concerned about the due on sale clause, where you put a 3-year lease in place because under Garn St. Germain, a 3-year lease is allowed. They can't call the due on sale for a 3-year lease with a open purchase contract and an extended escrow. So the purchase contract is very similar to an option, but it's a purchase contract because, I'm not aware of any lender ever calling the due on sale because there's a memorandum of a purchase contract out there. Right. And so, you can have that purchase contract, put it in escrow. You can even provide for, payments or release of as earnest money with a release of that earnest money over time to the seller so that the seller's, receiving some compensation. But for subject twos, I think that's a great strategy if you're really concerned about the due on sale, because you're basically kind of going around the due on sale clause. And even some due on sale clauses, if you analyze them, they don't prohibit that exact strategy. And so you don't even have a due on sale violation if you structure it that way sometimes.
Then you kind of run the risk, depending on the state, if you're doing a lease agreement, because typically investors want the end buyer to be responsible for maintenance and repairs. But then you can run into a situation, depending on the state, where they say, okay, it's a landlord-tenant law, and the owner of the property is technically responsible for the maintenance repairs. I don't know if you ever came across that. What are your thoughts on that?
Yeah, and that is a very accurate statement, and that's one of the downsides of the lease with option or lease with purchase contract, is because, of course, the lease is going to say you can sublet as the investor, and so you're going to sublet. You can contract around a lot of things within a residential lease with proper disclosures, but generally the thing you cannot contract around is habitability. So you still have to provide a habitable dwelling. And so in Arizona, for example, you have to have AC, heating, electrical, plumbing. Those types of things have to exist on the property, and you're responsible for those. You can't say, oh no, tenant, that roof's leaking. No, you replace the roof. It doesn't work that way. You have to provide a habitable dwelling, which is your responsibility as a landlord. So, but you can foist, basic maintenance, repairs, those types of things, changing light bulbs, painting, exterior, interior, or front or back landscape, flooring, those types of things. You can foist upon the tenant with the right disclosures, but you cannot foist habitability on the tenant, unfortunately. So that's the real downside for the lease situation.
So as long as you have especially if you have like the strategy you're talking about, especially if it's a newer home or it's a beautiful home, you feel comfortable with it. Some of the older homes, what I tend to do is I will put like a home warranty in place on some of it, to
Mhm.
kind of on some of it. So that helps when you're selling it to an end buyer, tenant buyer, if you will.
Mhm.
That's kind of what I do, because you still want them to be responsible for the maintenance and repairs, but certain states may throw out, and I've seen that happen, where they throw out the purchase sale contract and like, okay, we're going to go with the lease agreement, and then all of a sudden they come up with all these receipts of repairs that they did.
Oh, and you want to go with the lease agreement. You frankly don't even want your lease agreement to reference the purchase contract. So, you know, because the minute a judge in Arizona, when we do evictions, we go to municipal courts, and in municipal courts, those justice of the or JPs or justice of the peace, most of the time they do a pretty good job, but maybe about half of them are attorneys. Because it's an elected position, and all you have to have is a high school diploma to be a justice of the peace in Arizona. And so, and I'm not in any way disparaging them. I mean, they, like I said, I've been in front of justice of the peace who weren't attorneys, who did a better job than the ones who were attorneys. But with that said, is they only want to hear what they're comfortable hearing. And so if they receive an eviction action and they start going through that lease and they see an option to purchase or a purchase contract referenced, or, you know, part of the rent is going, you know, towards the purchase price under some other agreement, they're going to throw up their hands and they're going to say, this involves title to real estate. It's outside of my jurisdiction. Go to Superior Court. And now you're in a quiet title action, which is, you know, a lot more expensive, a lot more time consuming, and it's a real mess. So you want to basically be able to go in and just show the lease and say, look, judge, they violated the lease. They haven't been paying. And now there's still a risk that the tenant shows up and starts waving the option or purchase contract around.
It's happened to me.
It happens. Yeah. And they start waving it around and the judge's like, oh, sorry, quiet title action, you know. Now, not every tenant's going to do that. Some may, if they know what they're doing, or their attorneys definitely will. But there's always a risk anytime you have a lease and you pair it with a purchase contract or an option to purchase, that it's going to mucky up your eviction proceeding. But you try to at least guard against that by having a basic lease that, you know, you can still have provisions in there as far as repair and maintenance and stuff like that. That's fine. But you just definitely don't want that lease to reference the other documents. Now, you can have the other documents reference the lease so that if there's an eviction or a breach of the lease, that those other documents terminate. But definitely keep the lease a standalone document.
Yeah, you got to be careful in the states, certain states, when you go ahead and try to do eviction, the state will automatically give the tenant legal aid assistance. So you got to be careful, and that's what happened in my case.
Yeah.
The legal aid got involved, and then all of a sudden they came up with thousands and thousands and thousands of dollars of receipts out of the air, and then they went with the landlord-tenant law. So
Yeah. Yeah.
it is what it is. That's part of
Yeah.
the game. You're going to have some winners
Right.
and you're going to have some losers. So you just got to be
Right.
careful of the state and just make sure you understand everything. But, you know, when you've been through quite a few of them, or not quite a few, but when you go through this stuff, you kind of learn. And like you said, you just have
Right.
the right provisions, and, you know, you just, you know, give them a credit for maintenance and repairs monthly in their lease agreement type of thing. So,
Right. Yes,
yeah.
exactly.
So
Yeah.
that's good stuff. So, you know, we're coming to 50 minutes. I know I was going to ask you a question about trust, setting up trust in your estate purposes, but maybe we can have you back on and talk a little bit more, because there's a lot of information that we could go on and on. But Sean, how can people reach you and how can people locate you?
Yeah. So the best way to reach me is to basically through my direct line. And it's 480-359-7206. It rings right to my desk. And frankly, if I'm sitting there working on something and I can be distracted for a minute or two and my phone's ringing and it's not showing a spam call, I generally will pick it up and answer it. And that really is the best way to reach me. And then I return all voicemails generally within 24 business hours. And if you send an email or message me through social media, it could take longer than that, just because I am inundated with those types of communications. So the quickest, most efficient way to reach me is simply pick up that phone, dial my direct line 480-359-7206, and I'll be happy to, chat and let you know kind of how you can work with me, or if you need referrals to attorneys in other states, I'm happy to provide those as well.
And your firm also, you guys do a podcast too, if I recall correct.
Yes, so we actually do two podcasts. So the first one is a more formal interview style podcast, kind of like what we did today, where we have guests on and we interview them. It's called the In Rem podcast. So INREM podcast, which is Latin for real property. So it's the In Rem podcast, and that's on Tuesdays at 10 a.m. Arizona time. Then we also do the Creative Finance Collective, which basically we have attorneys from other states that come on with us, and we chat about creative finance primarily. And then we spend a lot of the time, though, answering questions that are presented by the audience. So we probably spend about a third of the time chatting amongst ourselves about different creative finance topics, and then about 2/3 of the time answering audience questions. And that is at 2 p.m. Arizona time, also on Tuesdays. So Tuesdays at 10 a.m. for the Interim podcast, and Tuesdays at 2 p.m. Arizona time for the Creative Finance Collective.
And then the creative financing one, just so you guys are listening, they also go live in the Seller Financing Homes group, and if you're on Facebook, they go there. Or you also, I'm assuming you have a YouTube channel they can watch it through as well.
Yeah, so we have a YouTube and Facebook channel for INREM. So if you go to YouTube and you type in INREM podcast, you'll bring up our feed and our videos, and you can like and subscribe. And then you can do the same with the Facebook page as well.
Really, really appreciate it. Once again, your firm, what do you guys do at your firm you specialize in? We can just kind of close it out and talk a little bit one more time.
Yeah, so our firm is made up of 8 attorneys, and we basically do most things real estate as well as some personal injury work. So we have a whole plaintiff's personal injury department that handles injury claims both in Arizona and Wisconsin. And then as far as our real estate practice goes, we handle real estate litigation, we handle probate, and then I handle all of the real estate and business transaction work for our clients, both in Arizona and Wisconsin. And then we also have offices in Georgia as well, although I'm not licensed there, but we have 2 attorneys that are licensed in Georgia as well.
Perfect. And also, you guys help investors set up the trusts, asset protection trusts, I'm assuming, as well, to protect their assets.
Yeah, so we actually we don't do irrevocable trusts. I generally will refer that work out, and that is your asset protection trust. But we will do your probate avoidance trust, which is your revocable trust, and full estate plan as well. The pour over wills and powers of attorney, healthcare directives, all of that is what's included in a basic estate plan. And so we do those trusts, but the irrevocable, it's a little, kind of different animal, which involves getting EINs and tax returns, and you have to really structure those properly. And there's some high-end estate planning attorneys that will refer those to, and those are your asset protection vehicles.
Perfect. Sean, thank you so much for coming on Real Estate Power Play. And, for everybody listening to us, please like us, share, leave a comment on your favorite podcast platform or wherever you're watching and listening to us. Sean, thank you so much. I really appreciate it.
Thank you, Mark.